Something never seen before has just occurred in the United States, and the system recognizes it. This is not about protests or elections. During an active federal criminal trial, a judge did something no court has ever done. While the trial was still happening, still in progress, a federal judge officially sent impeachment evidence straight to the United States Congress. Not just a suggestion, not a brief summary, the actual evidence itself. This never happened during Watergate. It never happened with Nixon. It never happened with Clinton. It has never happened until this moment. That one action is why Washington instantly went into crisis mode. National Guard troops were brought in. Security barriers were expanded around the Capitol. Lawmakers were called into private emergency meetings. This was not just for show. It was the system reacting to a real emergency. When courts respond like this, it means the normal system of checks and balances can no longer handle what is taking place. Judges are taught to avoid making things worse whenever possible. They do not get involved in impeachment processes unless waiting becomes a danger to our legal system. That breaking point was reached inside a federal courtroom, quietly following proper procedures with serious consequences. What came next was not disorder. It was organized action. Federal marshals removed Donald Trump's entire legal team from the courtroom for lying under oath. Not for bad behavior, not for breaking courtroom rules, for perjury, which is a felony crime. 17 separate false statements that were proven wrong by emails, computer records, and financial documents the court already possessed. When they were confronted with the truth, the lying did not stop. That is when the trial stopped being just a normal trial. At that exact moment, the courtroom became a constitutional breaking point. Presidents have survived scandals for many decades by delaying things, using appeals, creating delays, causing distractions. That option disappeared the second a judge compressed years of political delays into a judicial decision made in just hours. The timeline is no longer controlled by politics, it is controlled by the court, and court timelines do not stop. This is why everything suddenly feels so different right now. Not because of what people are saying, but because the system itself has started to take action. What happened after that inside the courtroom explains why this situation escalated so quickly and why it could not be stopped. Courts do not run out of patience quickly. Judges give warnings. They allow people to fix their mistakes. They give lawyers every chance to pull back from crossing the line. That entire process happened here multiple times. And every single time the defense chose to keep going under oath, Trump's legal team denied that specific communications existed. Not one time, not two times, 17 separate times. They told the judge those emails were not real. They told the jury there was no documentation. They told the court there was nothing to look at. But the court already had those documents, emails, computer records, financial papers, time-stamped evidence that directly proved the sworn testimony was false. When they were confronted with this, there was no attempt to explain, no attempt to correct the record, no attempt to take anything back. The lies kept going. And at that point, the nature of what was happening completely changed. Legal defense turned into criminal behavior. Perjury is not a legal tactic. It is a felony crime, and the court handled it exactly that way. Federal marshals were given orders to take action. They walked up to the defense table. Trump's attorneys were told to stand up and were physically walked out of the courtroom in public in full view of cameras, the jury, and the official court record. This was not done to embarrass them. It was the enforcement of court rules. The system was asserting its authority. Most trials would have stopped at that point. New lawyers would be assigned, and the trial would continue. But this court did not simply move forward. It paused, evaluated the situation, and then took things further. The reason is that the problem was no longer just about lawyers lying under oath. The question now became whether that perjury was instructed, whether it was planned, encouraged, or commanded in order to block the court from doing its job. That question cannot be ignored when a sitting president is part of the case. Once a judge decides that obstruction might be connected to presidential power, staying neutral is no longer possible. Courts are not permitted to pretend the problem stops with the defense lawyers. At that moment, the judicial system is legally required to protect the integrity of the legal process, even if doing so triggers consequences that reach far beyond the courtroom walls. This is the boundary that was crossed. The trial stopped being a place to decide facts and became the starting point for a constitutional crisis, not because the judge wanted to make things bigger, but because refusing to escalate would have meant letting the judicial process itself be damaged, and that is why what followed could not be avoided. To understand how serious what happened next truly was, you need to understand how extreme the judge's situation had become. Federal judges are taught to stay away from politics with almost extreme focus. They do not guess about what people intended. They do not point toward impeachment. They do not insert themselves into the power structure unless the other option is complete system breakdown. That is the point this case had reached. Once lying under oath was confirmed, The court was facing a question much more dangerous than any single lie. Was the judicial process itself being blocked in order to protect presidential power? When attorneys lie repeatedly in a coordinated way, courts are required to figure out whether those lies were ordered, whether they served a bigger goal, and whether the misconduct was part of a larger plan to interfere with court oversight. At that point, the judge was no longer just running a criminal trial. He was dealing with a constitutional crisis happening right in front of him. If the court had simply brought in new lawyers and kept going, it would have basically allowed the alleged obstruction to work. Delaying would have rewarded the misconduct. Staying silent would have made it normal, and making things normal is how institutional boundaries fall apart. Not with loud arguments, but with precedent. This is why the judge did something no federal judge has ever done while a trial was still happening. He issued a formal order stating that obstruction of justice and perjury represent impeachable high crimes and misdemeanors in connection with the behavior that occurred in the court. That specific language is important. It was not theoretical, it was a statement of fact. It established that the line for congressional action had been crossed. Then came the procedural step that changed everything. The court gathered the evidence, certified it, organized it with an index, and sent it directly to the House of Representatives. This was not information being leaked, not a suggestion letter, not a recommendation. It was an official judicial transmission, complete, sealed, and formal. Courtroom transcripts documenting 17 false statements. Emails the defense said did not exist. Financial records that contradicted sworn testimony. Body camera footage showing federal marshals enforcing the court order. By doing this while the trial was still going, the judge destroyed decades of presidential defense tactics in a single moment. The clock that presidents depend on. The appeals, the delays, the political distractions stopped being effective. Congress was no longer able to wait. The system had been put into action. Courts only take steps like this when they believe that waiting itself creates a danger to the rule of law. And that is what makes this moment different from every scandal that came before it. The judiciary did not react to politics, it reacted to a threat. And once that line gets crossed, there is no going back to the way things were. The transmission itself was just the start. What shocked Washington was not only that evidence had been sent to Congress, but what that evidence actually included and how thorough it was. This was not an incomplete record or an early conclusion. It was a complete package, certified, organized, and impossible to reject as just speculation. Inside the package were complete courtroom transcripts documenting 17 separate lies told under oath, emails the defense claimed did not exist, complete with computer data confirming dates, who received them, and tracking of how they were handled, financial records that contradicted sworn testimony line by line, body camera footage showing federal marshals escorting Trump's legal team out of the courtroom for perjury. Public, procedural, impossible to deny. And then there were the recordings that were never supposed to be heard by the public. Audio recordings in which Donald Trump is heard telling associates to ignore court orders. Other recordings in which judges are threatened. These were not information being leaked. They were official exhibits sealed, verified, and transmitted as evidence. Once those materials were delivered to congressional possession, denying what happened became impossible. This is why the response on Capitol Hill was instant and serious. Lawmakers did not need someone to explain it to them. They had documentation. They did not need political spin. They had court-certified facts. For decades, presidents survive scandals by using up time. They fight legal battles endlessly. They appeal every decision. They let public attention move on. They let elections create new situations. That strategy depends entirely on time. The judge eliminated it by transmitting impeachment evidence while the trial was still happening. The court turned years of political maneuvering into a matter of days. Congress was no longer working on their own schedule or being cautious. They were working on a judicial timeline, and judicial timelines do not stop for political rallies, messaging campaigns, or threats. This is when panic began, not in public, but within the institutions. The reason is that once evidence is this complete, delaying becomes dangerous. Every hour of not taking action creates the question that no lawmaker wants to be asked. Why did you wait? And once that question exists, staying silent stops being the safe choice. What changed the feeling in Washington was not anger. It was the sense that what was coming could not be stopped. The system had moved from arguing to simple math. And when evidence reaches that level of clarity, the question is no longer whether Congress will act, but how quickly it can move. What many people outside Washington did not realize is that impeachment did not start with the judge's transmission. It was triggered by it. The system was already in place, waiting for the one thing that politics alone could not deliver, which is court-certified evidence. Long before the courtroom turned into a crisis, a House impeachment resolution had been quietly written and prepared. Not created in a rush, not done as a reaction, fully written, legally organized. 7 articles, specific and serious. It addressed bribery connected to emoluments violations, abuse of power through the wrong use of executive authority, obstruction of justice, contempt of Congress, violation of the oath of office, and conduct related to discussions about using the military in a forceful way that lawmakers privately called tyrannical. For months, that resolution stayed inactive. It had people who supported it, but not enough supporters. Around 120 co-sponsors, mostly Democrats to the small number of Republicans. Leadership knew the reality of the numbers. Impeachment does not happen because people are upset. It happens when there are enough votes, and the votes were not there yet. That situation changed the second the judge's evidence was delivered. The transmission did not bring new accusations. It brought actual proof. Evidence collected under oath, evidence verified by a federal court, evidence that eliminated any confusion and destroyed the last attempts to argue against it. Once transcripts, audio recordings, and body camera footage were available, lawmakers who had been uncertain were pushed into making a new decision. Could they defend this situation on television? Could they explain their silence when under oath? Could they justify doing nothing once the facts were this obvious? For many of them, the answer was no. Names started being added to the resolution quickly and in public view. Republicans who had supported Trump just days before put their signatures on it. Some released public statements, others stayed silent, but the total number kept going up. By the middle of the day, it crossed the threshold that cannot be reversed. 220 co-sponsors, which is a majority of the House of Representatives. At that moment, impeachment stopped being something that might happen. It became a mathematical certainty. Leadership did not need to pressure people or make deals in private. The votes were already counted and recorded. Waiting now created risk. Every hour that passed increased vulnerability. Every moment of silence became noticeable. This is why the atmosphere in Washington changed so suddenly. Not because people's opinions shifted, but because what was coming became unavoidable. When the vote count is locked in, political maneuvering stops. The official process takes control. And once that process starts moving this fast, no president has power over what happens next anymore. Once the vote count was confirmed, the split inside the Republican Party stopped being just a possibility. It became real and visible. This was no longer about party loyalty or staying on message. It was about personal risk. Lawmakers are trained to assess danger, and the danger calculation changed almost immediately. Until that point, many Republicans had used a familiar approach: wait and see, deflect questions, challenge people's motives, avoid taking a clear position. Either way, that approach requires uncertainty to work. The judge's evidence eliminated it. Court-certified transcripts, verified audio recordings, and video proof of attorneys being removed for lying under oath cannot be twisted or reinterpreted. They cannot be dismissed as exaggeration from the other political party, and they cannot be defended without facing personal consequences. This is how loyalty actually falls apart, not because of beliefs or ideology, but because of self-protection. Every additional hour of staying silent created the same internal question. Can I defend this if I am forced to explain myself, not in a written statement, not on a friendly news channel, under oath, in campaign advertisements, in the historical record? For many lawmakers, the answer came quickly, and it was uncomfortable. People began breaking away quietly at first. Then the pace picked up, not from minor figures on the edges, but from lawmakers who had defended Trump in public and done so repeatedly. Some held press conferences. Some put out short statements. Others simply added their names to the resolution and made no comment at all. But the message could not be misunderstood. This situation cannot be allowed to continue. What made this break different from previous times when the Republican Party showed disagreement was how fast it happened. Once the first few names switched positions, others followed. Not because their core beliefs changed overnight, but because waiting became more dangerous than breaking away. In Washington, being one of the first to act can be risky. Being one of the last can be career-ending. Behind closed doors, conversations became direct and honest. Can you explain this to the voters in your district? Can you justify it to the people who fund your campaigns? Can you defend it to investigators? If your emails and communications are legally demanded as evidence, the existence of recorded threats and documented obstruction changed the entire situation. Defense was no longer about loyalty. It became a legal liability. This is the moment when party leadership lost control of the story. When people break away in real time, party discipline falls apart. Vote counters stop tracking numbers and start managing the damage. Coordinated messaging stops and planning for worst-case scenarios begins. The question changes from how do we protect the president to how do we protect the party and ourselves. This is why the split feels like it cannot be repaired. It is not based on emotion. It is based on following procedures and protecting oneself. And once a political party starts acting out of fear of evidence instead of fear of public criticism, the break does not get fixed. It gets wider. At this stage, Trump was no longer dealing with people opposing him. He was experiencing people abandoning him completely. As Congress took action and Republicans abandoned their support, Donald Trump did the one thing that made certain the situation would get worse. He refused to stay quiet. Under normal conditions, showing restraint might have reduced the damage. Instead, Trump made things bigger and more public, turning pressure into a public show. And in doing so, he turned his words into legal evidence. His social media posting changed from defiant to unstable. Not careful statements or legal arguments, but messages in all capital letters, personal insults, and accusations mixed with conspiracy theories. In the past, this kind of behavior energized his supporters. This time, it had legal consequences. Every post was marked with a time and date, saved in archives, and kept as a record. Every threat made the evidence file larger. When a president attacks judges while he is actively being reviewed by the courts, it is no longer just political speech. It becomes witness intimidation. When he encourages people to resist Congress as it uses its constitutional power, it is no longer just messaging. It becomes incitement. And when Trump warned that there would be civil war if he was removed from office, the line was completely crossed. That statement was not treated as exaggeration inside Washington. Law enforcement agencies see statements like that as signals, not just opinions. Signals that change how people behave, increase risk levels, and require preparation. From a legal perspective, the harm was even more obvious. Threats against judges make obstruction cases stronger. Calls to disobey Congress support contempt charges. Trump was not defending himself. He was creating a record of his own wrongdoing. This is what falling apart looks like. Not a sudden crash, but increasing self-caused damage. A president who used to depend on being unclear was now creating absolute clarity. And clarity is the one thing that power cannot survive when the legal process has already started moving. As Trump increased his aggressive language, Washington moved from discussing what to do to being ready for what might happen. National Guard troops were brought in. Security barriers were made tighter. Intelligence agencies started watching threat situations as they developed in real time. This was not panic, it was getting prepared. January 6th was no longer just something that happened in the past. It was knowledge that guided current operations. When a sitting president uses the language of civil conflict, institutions are required to act as though words can turn into actual violence. At the same time, something more significant was happening that was not visible to the public. Trump was no longer facing just one path of accountability, but several happening at the same time. Impeachment moved forward on a court timeline. Criminal liability advanced at the same time with perjury, obstruction, and witness intimidation, no longer just theories. And quietly, serious discussions about constitutional inability to serve under the 25th Amendment began happening. None of these processes needed Trump's agreement to move forward. None of it could be stopped by stalling or running out the clock. This was the moment when power stopped bending to personality and began answering to procedure. The presidency didn't unravel because of a single dramatic vote, but through accumulation, evidence stacking up, timelines tightening, votes being counted. Even if the Senate ultimately refused to convict, there was no path back to normal. Once authority fractures, it doesn't simply reassemble itself. Every decision would invite resistance. Every order would be scrutinized. Governing would turn into a constant battle. This is how systems dismantle illusions, not with spectacle, but with process. The illusion that power can outrun the law. That delay equals immunity. That authority belongs to an individual rather than being constrained by the Constitution. What remains now isn't Trump's personal will, but a system he no longer controls. And once the system reaches this stage, what comes next is no longer a matter of choice. History has stopped waiting.